Mediation is a term that anybody going through a contested divorce in Utah will become familiar with. It's a process that you must go through. It's an effort to try and settle your case outside of court and short of going to trial. Today I'm going to share with you some top tips to help you do your part to have a successful mediation and ultimately settle your divorce case in mediation. I'm Jaclyn Robertson with JR Law Group, and welcome to Family Law Friday. So a first tip would be, it's really important that you are mentally, physically, and emotionally prepared for mediation before the day even dawns. And what that means is, first of all, mentally, we've seen clients that are so overwhelmed and in the dark about what the process even looks like that we just encourage you to make sure that you ask your attorney and get informed on what the process is, because your worst nightmares of being on top of the other party in the same room and fighting and yelling, sometimes like we see on TV shows, is not realistic. You're going to be safe, protected in a separate room with your attorney. You're going to have, a carefully selected neutral third-party mediator that's really the only person that you're going to need to be discussing your case with, that you and your attorney will be discussing your wishes and your issues with. And the other party will be safely nestled away in another room with their own privacy and space. So you won't be on top of each other. It's designed to help you feel relaxed and open to options and to be expressing what you need from this. The other piece is, even on a physical and emotional level, make sure you try to get rest. Sometimes, you're going to eat on a different schedule than others, or lunch can be late because time flies during this process, believe it or not. Bring snacks, bring whatever you need, dress comfortably. You don't have to dress up. And so do all of these things to just feel like you are setting yourself up to be comfortable and do your work. Another tip would be, on mediation or before mediation, know what your goals are. Know what is so important to you. One of the reasons that I'm such a huge advocate for settling a divorce action in mediation is because the parties will have the most control over their decree. If you go to court and hammer it out before a judge, the clear black letter law of everything split in half generally will apply, and there's no room for creativity or how to give and take on different things that may be differently important to each other. So know what your goals are. I have an outline of what your objectives are on the custody front, on the finances. Understand where you feel absolutely strong about and that you can't give and take on. Understand the other areas where you're not so dedicated to a certain outcome, and just have an understanding. And a third tip is, make sure that once you've outlined and had a really thoughtful exploration with yourself as to what you expect from your divorce, make sure you are open, listening, hearing, asking your attorney about your expectations. It is so important that you ask them, are these expectations realistic? Is this something that I'm going to ultimately prevail on if we were to go to trial? And while there's no glass ball, and an attorney should never dispositively say what a court will or will not do, there are certain things that time and experience will tell your divorce attorney that this is not realistic because, or yes, this is realistic because. And they can also filter your goals and expectations through the laws to make sure that you have realistic expectations. Because what that means is, you're going to go to mediation, you're going to be sharing these goals and ideals with the mediator, and if they're reasonable, that gives them something to work with. It's going to help your case move towards settlement. If you're way off in left field and have an expectation that you would never prevail on in court, that is too one-sided, that's not consistent with the law, then that's going to be a lot harder. It can ultimately offend the other party. Usually the mediators are good at filtering stuff, but still, it can. If you have an unmoving position on something that's unreasonable, it's going to not set you up to settle your case. So if you can do those three things to prepare for mediation, you'll go to mediation in the best possible way that you can to set yourself up for a successful settlement, avoiding years of litigation and stress in trial. Alternatively, I will point out, you can't ultimately control the other party. You can't control what their expectations are. So there are some cases that still don't quite settle. Doesn't mean that your case is necessarily going to go to trial if you don't settle in the first mediation. But again, these are just tips today to help you set yourself up, you and your attorney, for a successful day in mediation so that you can get divorced and get on with your life in a fair and reasonable manner. Jaclyn Robertson with JR Law Group. If you would like to schedule a consultation and speak about your specific case or have questions, go to my website at jrlawgroup.com. Give us a call. As always, follow us on Instagram at JR Law Group, and thank you for joining us for Family Law Friday.